Hi, everyone. I'm Shoikhetbrod. I'm one of the managing partners at Tully Rinckey in the Albany office. I'm also one of the team leads of our federal labor and employment sector here and the practice chair of our New York State labor and employment sector. In my practice for federal labor and employment cases, I've handled a lot of them throughout the many years I've been here, throughout different processes, including the EEOC, the Merit Systems Protection Board, the Department of Labor, the VA, Disciplinary Appeals Board process, Foreign Service Grievance Board, and a lot of different cases with a lot of different agencies, really all over the world, because some of our clients can be stationed outside of the United States. So I've handled a lot of different matters. And so today we're focusing specifically on due process rights of federal executive employees. So what you'll learn today is understanding your employment status and how that specifically impacts your due process rights. Handling investigations that may be done internally by your employer for alleged misconduct, some common adverse actions that we've seen in the workplace, how to reply to a proposed disciplinary action that might be issued by your employer, performance improvement plans, but also particulars with regard to Chapter 43 performance-based actions and how those are different or sometimes the same as Chapter 75 actions. Understanding your appeal rights, if you have appeal rights, to the Merit Systems Protection Board, and the benefits of hiring an attorney throughout this entire process. Just keep in mind that we're going to be focusing specifically on federal executive agency employees. So the first thing to consider is when you or an employee may be subject to an investigation by your employer. Sometimes it could be a voluntary or a mandatory investigation, and these investigations are done typically before any proposed action is taken against that employee. If voluntary, usually the inquiry has to do with some sort of stealing or fraud that may have occurred where there might be a criminal component, and therefore your Fifth Amendment rights to remain silent do vest at that point. And if that does occur, there are certain rights that are attached to that, and we'll go down the list later on, but one of which is Cal Kynes warning, where you don't have to participate in that investigation because it would be detrimental to what may come on the criminal side of it. There can be a mandatory investigation that's done, and if you end up refusing to engage in that investigation, you can be brought up on disciplinary charges just for your refusal of participating. So when there's an investigation, typically there's various warnings that may be provided. I mentioned briefly the Cal Kynes warning that's mentioned here that compels employees to make statements or face disciplinary action, which may include removal, but also provides them with criminal immunity for their statements. There are the Garrity warnings that advises employees of their criminal and administrative liability for any statements they make or may make, but also advises them of their rights to remain silent on any issues that may implicate them of crime. And that's kind of similar to what we may refer to as the Miranda warnings in a criminal law context. For union employees, they also have Weingarten rights, and that's essentially letting them know that they have the right to a union representative during these investigations, and really for a representative to be there should they have any questions about the process. So these are the typical warnings that an employee may receive or should receive when an investigation is done, typically for misconduct prior to an adverse action. You must answer truthfully to the questions being asked. Yes, here it says you could be prosecuted for perjury, but really what we've seen in our practice is that if you are under an official investigation, those investigations tend to be recorded, whether it's audio or there might be a person there taking notes, subsequently drafting your statement for you for your signature. And if you are not truthful or forthcoming or candid, you could be brought up on charges just for that. Lack of candor or falsification that type of thing. So types of disciplinary actions federal employees would see. One is a letter of reprimand. Usually there are due process rights attached to a letter of reprimand. If a letter of reprimand is subsequently issued, it's something that would remain in your personnel file. Luckily, however, a lot of agencies have different policies of how long a letter of reprimand may stay in your personnel file. Some agencies have a 6-month time frame. Others can go up to 2-3 years sometimes. But it really is kind of the lowest form of discipline that would be issued to an employee. Another form is a suspension. It could be a suspension of 1 day, and it could be, I've seen suspensions that have gone to 90 days. Depending on the length of the suspension, also depends on what type of due process and what your appeal rights may be from there. But suspensions generally are permanent in the sense that they stay in your personnel file and they will follow you in your career in the federal government. Another one is a demotion. Typically, you see demotions for performance-based actions under Chapter 43. If you're not meeting a critical element in your position, your employer can decide to demote you to a lower graded position. And that's something that would be typical in a Chapter 43 action, although I've seen it in Chapter 75 cases, especially when you have supervisors that are being proposed for demotion to a non-supervisory position. And then finally, the biggest one, which is removal or termination from federal service, not just from the agency, but from federal service. It could be, based on one charge with one specification. It could be multiple charges with multiple specifications. But usually by the time you get to removal, the agency and the federal government should engage in progressive discipline. So you'll typically see the progression from a reprimand to suspension to maybe a greater suspension before removal is issued, but it also depends on why or what the charges are that bring forth that removal. So employment status and due process rights. There are various different statutes that authorize agencies to take action against their employees. I mentioned Chapter 43 and Chapter 75, but Chapter 43 actions are really based on performance-based reasons where you're not meeting a critical performance element in your job. Chapter 75 actions are typically for misconduct, but they can also be used for performance reasons. And there's, again, different analyses that we'll see on other slides as to the differences between these two statutes. Chapter 74 applies to the VA, and specifically for employees defined under Chapter 74, 7401, and so forth. And those tend to be physicians, dentists, nurses, medical professionals with licenses. And then there's Section 714, which was passed through the VA Accountability Act, that applies to everyone else in the VA. So police officers, medical support technicians, medical support assistants, other individuals at the VA that are not defined as employees under Chapter 74. So for more serious disciplinary proposals, it really does depend on whether you're in the competitive service, whether you're in the accepted service, whether you're a probationary employee, whether you're a non-probationary employee. So the definition of an employee is actually by statute. It's at 5 U.S.C. 7511, and the implementing regulations are 5 CFR 752. So to be defined as an employee that has due process rights, they must not be a probationary employee. In a competitive service, they have to have completed at least 1 year of current continuous service in the same or similar positions. What that means is that if you start a position as a competitive service employee, you need to be in that position for at least a period of 1 year before you are considered to be, quote unquote, an employee, someone with tenured due process rights. Should anything happen at your job where you would get notice and opportunity to respond to an action and then subsequently have the right to appeal that action. There are a lot of employees that join the federal service or have joined the federal service years ago and have transferred agencies. Depending on the position, depending on the agency, that prior service can tack on if it's in the same line of work. So your prior service may be used. And so there are agencies that incorrectly have their employees considered to be probationary when in fact they are not probationary. And we have prevailed on a lot of cases as a result of the agencies getting that wrong for due process violations. There are certain aspects that are a little different depending on which agency that you're employed in. For example, the Department of Defense employees, which includes the Army, Navy, Air Force, and so forth, they have a 2-year probationary period in the competitive service. And that was by statute. That statute has been repealed through the National Defense Authorization Act for fiscal year 2022. But don't get too excited. That has only been repealed and only impacts new DoD employees, those who have been hired on or after December 31st of 2022. So any new DoD employee after that date is now under a 1-year competitive service appointment. Anyone before that is still under the 2-year probationary period. And then we have employees in the accepted service, again, defined by statute as someone not serving in a probationary period or has completed 2 years of current continuous service in the same or similar positions. A preference eligible veteran in the accepted service only needs to complete 1 year of current continuous service. Again, since we're focusing on federal executive agencies, this is important for Postal Service employees, for example, that are preference eligible. They might have board rights, but not all Postal Service employees have board rights. So I mentioned there would be differences shown here between Chapter 43 and Chapter 75 on performance-based actions. This chart was taken from the Merit Systems Protection Board, and we'll talk about what that Merit Systems Protection Board actually is. But as you can see, there's a lot of differences. For Chapter 43, again, we're focusing on performance-based actions under both 43 and 75. Under 43, the agency must only prove that there's a performance deficiency in one critical element. You may see agencies that say there are multiple performance deficiencies in multiple critical elements, but all they need to do is show just one. Under 75, the agency is not required to prove a performance deficiency in a critical element. They can just say there's performance issues and bring you up on a performance-based action under 75. One of the aspects for 75 cases is that not only does the agency have to prove there was an issue with performance or misconduct, but they also have to show a connection to the impact of the efficiency of service. Under 43, the agency is not required to do that, which is another big difference between the two statutes. The burden of proof is also very different. For Chapter 43, the agency only has to show that there's a performance deficiency by substantial evidence, while under 75, the agency's burden is by preponderant evidence. Substantial evidence may sound like it's a lot of evidence. It's not. It's actually a much lower standard than preponderant evidence. Substantial evidence tends to be any evidence, absolutely any evidence showing that there's a performance deficiency. And a lot of times that will be enough to establish a performance-based action being taken. While on a 75, by preponderant evidence, the standard is whether it's more likely than not that there's a poor performance in that employee's case. There's also the establishment of performance expectations, and that's listed here. The agency basically has to show that their performance system has been adequate and has been accepted by the Office of Personnel Management, that the employee has been warned of the poor performance and so forth. For 75, it really goes into mitigating factors under Douglas, which we'll talk about briefly, as to whether or not the employee was made aware of the performance deficiency. And that really goes in terms of the penalty that's being proposed, whether it's a removal, demotion, or otherwise. For the recency of events under 43, the performance-based issues can only go back 1 year. I think we jumped ahead there, Taylor or Dave. But the performance-based issues can only go back to 1 year. So if the employer is looking at performance-based reasons to take an action that occurred in February 2022, that would not suffice. And ultimately, an administrative judge would not consider that. But for 75, there is no recency requirement, although the longer the agency goes back, the more it seems unlikely that there's really much merit to it. A judge may see it's not very credible, but it really depends on a lot of different circumstances. The advance notice period is the same for both 43 and 75. The content of the advance notice does differ a little bit. On the 43, really they need to show what the basis is and that the critical performance element that's involved. And the 75 just state the particular instances of the performance issues. The deciding official for 43 has to be someone up the chain of command, while on 75 it does not. It could be someone else who's not in your chain of command. The agency decision typically is done within 30 days from when the proposal is issued. And then from there, if there's a decline on improving your performance, essentially a new PIP could be issued. And then for 43, there's no penalty mitigation. So if they propose, let's say, a removal, and you argue that penalty is too harsh, well, there's no mitigation. And ultimately at the American Citizens Protection Board, where a lot of these cases get appealed, the administrative judge cannot mitigate the penalty. But on 75, you can. And that's where the Douglas factor analysis, pretty operative case, that talks about 12 different mitigating factors that may result in mitigating a penalty from removal to maybe a reprimand or suspension. You are allowed to raise affirmative defenses if you believe you've been discriminated against, for example, or you've been subjected to whistleblower reprisal, or there's a due process violation. Those affirmative defenses can be raised under both 43 and 75. And the merit principles must be adhered to in all performance-based actions. All this was taken from the American Citizens Protection Board website, which is current and here for everyone to review should they want to. Briefly, Chapter 74, Performance-Based Actions, pertains again to Veterans Health Administration, VA employees, but specifically to those defined under 7401 and some of those other 74 provisions that include physicians, registered nurses, doctors, dentists, chemists, therapists, physical therapists, and so forth. They're all specific by statute and only applies by statute to 74. If there is a case that involves or includes a question of professional conduct or competence in which a major adverse action is taken, that appeal is then taken to the Disciplinary Appeals Board. What a major adverse action is again, a removal, suspension, something like that, a demotion. And there's very particular options for those employees, but the big option is the Disciplinary Appeals Board, where that doctor, for example, can file their appeal and be heard by a panel of other providers, typically 3 providers, a chairperson who oversees the proceeding, someone who's another person, a member of the board who's in the same field as the employee, and then a third person who typically is not in the field but is also on the panel, and then there's a technical advisor. And the Disciplinary Appeals Board generally does not provide for an opportunity of discovery, but it is a full hearing process that can take 1 day, it can take several weeks, but ultimately the Disciplinary Appeals Board makes a recommendation that goes to finally the undersecretary's level to either accept or implement, and then subsequently is issued to the employee. So for major adverse actions, those employees are also entitled to advance notice stating the basis of each charge, the procedures, the regulations, and the instructions that have been violated. They also are entitled to all the evidence in support of the major adverse action that's being issued. They have the right to a representative or an attorney. They only have 7 business days to respond, and they only have a very short period of time to then appeal to the Disciplinary Appeals Board. But the aggregate period from when the charges are brought to when a decision is reached before it is appealed is only 15 business days. And that is very particular to the VA. So once an appeal is filed to the Disciplinary Appeals Board, again, focusing on major adverse actions involving a question of professional conduct or competence, the board will do a couple things. First, they'll look at jurisdiction, one, to make sure that they have jurisdiction over this. And I've had cases before where they thought they had jurisdiction, but didn't have jurisdiction, and it was a waste of everyone's time. But if they have jurisdiction, again, they have to issue a decision. And unless the employee waives their statutory right to a decision of 45 days from when their appeal is filed, or no longer than 120 days, just total duration, the Disciplinary Appeals Board can take a long time. I am actually handling a case right now where the appeal was filed about a year and a half ago, and we are only going to hearing on this case in 2 weeks. And the reason why that's happening is because my client waived the statutory deadlines because there are some other issues involved, other EEO claims or otherwise, and so that can happen. And sometimes that's actually not a bad thing because it allows you to prepare and present your case more thoroughly. Also, I believe the board appreciates more time so they can get acquainted with what the case is about. But generally, it is a hearing process. So testimony is taken, direct testimony, cross-examination, redirect. Evidence is submitted to the board during the hearing. Sometimes they want legal briefs, sometimes they don't want legal briefs. It really depends on the composition of the board. But the board can mitigate the action. Let's say it was a removal, they can mitigate it to a suspension, or they can mitigate a suspension to a reprimand or to a lower suspension. But finally, from there, the employee has a right to seek judicial review. But the judicial review typically tends to be filing in a federal district court. So really, this is the only administrative opportunity for those employees that fall under Chapter 74 and that are brought up on major adverse actions. The only administrative review is at the Disciplinary Appeals Board. Subsequently, it tends to be court litigation in federal court. So 38 U.S.C. 714, and these are VA employees that are not covered in the prior slides under Chapter 74. Again, these can be, police officers, medical support techs, those types of employees that are not medical professionals that are licensed. So here's the list. This is taken from the statute as to who is not covered under 714. And again, it's all very quick. If the VA wants to take an action against their employees, whether it's performance-based or misconduct, they can use Chapter or Section 714. If they decide to use 714, there's a very short notice period of only 7 business days. So if you get a proposed removal under 714 today, you only have 7 business days from today to respond to that. There's case law that has said recently that the response can be either oral or written, but not both. And that is kind of distinct from Chapter 75 and Chapter 43. And I have a feeling it's because of how quick these deadlines are, and it's all by statute. And the decision, the agency's decision, the VA's decision, has to be issued within 15 business days after that notice is provided. So again, very quick turnaround. There's been a lot of case law coming down on 714 since it's been implemented. A lot of challenges to 714 with regard to penalty mitigation, with regard to what the standard and burden of proof is. It's really one of those statutes that have changed very much since it was implemented in 2018. But the firm has a lot of these cases, has handled a lot of these cases, and we are in tune with all the changes to the law. So 714 covers, again, removals, demotions, suspensions of 14 days or more. The difference between 714 and Chapter 74 with regard to appeal rights is that while Chapter 74 employees can only file their appeals with the Disciplinary Appeals Board, Section 714 employees can file their appeals to the Merit Systems Protection Board. Generally, whether it's a Chapter 75 or a Chapter 43 action, those appeals can be filed and should be filed within 30 calendar days. However, under Section 714, the deadline to appeal is only 10 business days. Again, very short compared to the other statutes. At the appeal level at the MSPB, the burden of proof is by substantial evidence, which is similar to the Chapter 43 burden of proof that we discussed previously. What's different, however, is at the agency level, it's noted here, if someone, a manager, brings you up on a misconduct under 714, at the agency level, the burden is by preponderant evidence, but if it's appealed to the MSPB, it's by substantial evidence. And by substantial evidence means not just the charges, whether it's, misconduct, but also the penalty. And so the whole decision needs to be supported by substantial evidence. What the MSPB cannot do is mitigate the penalty from removal to a suspension, but what the MSPB can do is say that the removal is not supported by substantial evidence, even if the charges are, and reverse the entire case and grant the appeal. So it's a big difference, and this is actually a very recent occurrence in case law that came down from the Federal Circuit in the last year and a half. From the MSPB level, those appeals can go up to the second level of the MSPB, which is the board. Maybe many of you know the board is 3 members. They're presidentially appointed, Senate confirmed, and the board was without a quorum for many years until recently. So now it is deciding these cases at the second level review. But the third level review is at the Court of Appeals for the Federal Circuit. So these cases can ultimately end up there. And the changes in the case law that I've been relating are coming down from the Federal Circuit. So the Federal Circuit has really changed this statute in the last few years, making it much more employee-friendly, providing many more protections under the statute to employees to make it consistent or more aligned with Chapter 75 and Chapter 43. So when your employer, your agency decides to issue a proposed disciplinary action, they're required to provide you notice of the proposed action, only if you are defined as an employee. Okay, we talked about what that definition entails under 5 U.S.C. 7511. Essentially, you have to be beyond your probationary period. And if you are beyond your probationary period, you are considered to be an employee, more accurately, a tenured employee. And if you are, then you're entitled to due process. And what that due process is here, you're receiving a notice of the proposed action against you. That proposed action will tell you what the charges are. For example, it could be conduct unbecoming of a federal employee, which is really the most basic charge an agency can launch against their employee. It could be anything's conduct unbecoming. It could be a lot of different things. And then under the charge, you would see the different specifications, which are the different events. So if it's conduct unbecoming, you'll see specification 1. March 20th, 2023, you said something mean about your supervisor to your supervisor's face, and it'll just go line by line, different specifications. So you'll see that, and all that is required to be provided in the notice. You'll also have the right to review the materials that the agency is utilizing in bringing forth this action, typically called the evidence file, and typically provided with the notice. You will typically receive, hundreds of pages of evidence that the agency is utilizing, but you have the right to not only receive and review that, but you also have the right to official time to review all of that, and you have obviously the right to respond to these charges. The agency typically cannot impose a greater penalty once they propose a penalty, but they can change the penalty to make it lower. So, for example, if you are being proposed for removal and you put in your response and you argue they're wrong and you have mitigating factors, the deciding official can decide to mitigate it to a suspension, for example. However, the agency can rescind a proposed action at any time and reissue it, okay? Sometimes you'll see that in VA cases a lot because of the statutory deadlines for them to issue a decision on the proposal. So they may issue a proposed removal, miss their 15 business day deadline to issue a decision, so they'll rescind it and then reissue it. Sometimes it'll happen in other cases because something else occurred. For example, if you got a proposed removal last Friday, but you did something over the weekend, they may want to reissue the proposed removal to include those additional specifications and charges. But regardless, you have the opportunity to respond, typically in writing and through an oral presentation, depending on what the charge is. When it's a suspension of 14 days or less, these matters cannot be appealed to the Merit Systems Protection Board, but they are still entitled to advance written notice stating the reasons that are being proposed for the action, a reasonable time to answer. Okay, so there's no real set time by law. Typically, you'll see it in the proposal. Usually it's 7 days. Sometimes it's more, but it has to be a reasonable time, and 7 days has been interpreted to be a reasonable time. And then finally, that you have the right to a representative or an attorney, and you have the right to a written decision and the reasons for that decision at the earliest practical date that they can provide. But for suspensions of 14 days, more than 14 days, removal, a reduction in grade or pay, which is a demotion, or furlough of 30 days or less, those can get appealed to the Merit Systems Protection Board, again, assuming you are an employee defined by statute. But the due process rights are also different. The employee receives at least 30 days advance written notice that they are being proposed for an action, and a decision of that action would be implemented in 30 days. There is one exception, and the exception, again, is under law if there's reasonable cause to believe that the employee has committed a crime for which a sentence of imprisonment may be imposed. But generally, when that's not the case, you'll receive a proposed removal, for example, telling you they cannot issue the final decision on that at the agency level for at least 30 days. You'll also be provided a reasonable time, but again, no less than 7 days to answer. What I've typically seen is, 14 days, maybe 10 days, and depending on the employer and depending on the allegations, a lot of employees also receive extensions. The notice will also say you have the right to a representative. The notice will tell you that you'll get a written decision and who the deciding official is. Just a note that the proposing official who issues the proposed action can be the same as the deciding official, unfortunately, but it could also be someone who's different. But it also will tell you what your rights are when you receive that decision, if that decision is effectuated. And typically that employee is entitled to appeal to the Merit Systems Protection Board. except for Chapter 74 employees. This is more of a recommendation. It's not something that's provided by law, but for us here, if we have a client who is brought up on discipline, proposed discipline, we typically tell them, or we do it for them if they're clients, to submit something called an interim reply. An interim reply is basically a request for information. Again, most of the time when a proposed action is taken, your employer will give you the evidence file. Sometimes they don't. So the interim reply would ask for the evidence file, but sometimes we go much more in detail as to the types of information we are seeking that we are looking for. We also request an extension, and we calculate that request to be from when we receive the requested documents in our interim reply. We also indicate that our clients want to present an oral response. And again, an oral reply under Chapters 43 and 75, that is a right that you have in addition to a written response. And we also indicate that we want the agency to preserve all documents related to that employee, and more particularly with regard to the actions that are being proposed. And we serve that letter on the deciding official and the human resources official that is essentially helping or telling the deciding official what to do. And we do that quickly. We do that quickly for a few reasons, because the employee has a deadline to respond to the proposed action. Sometimes the people who are receiving the interim replies will drag their feet and delay, sometimes intentionally, sometimes because they're out of the office. So we try to move very quickly because it's important to get this information, in our opinion, as a matter of due process, but secondly, really to strategize the approach and the reply that follows. So after the interim reply, and now it's time for the actual written reply, which is the substantive response to the proposed action. We like our clients to do a few things. In the response that we prepare, we do a little introduction as to why we're responding, pursuant to what notice, what deadline we had, and so forth. And then we get into the employee, really trying to build up their reputation, their character, their service, whether it's in the federal service, their military, private sector, whatever it may be, all the performance awards, all the great things that they have done in the federal government, and really building up the type of person they are, as opposed to looking at it in a narrow sort of minded sense as to just the proposed conduct that they're being charged with, or the proposed actions they're being charged with. But once we get through the employment background, and we typically do that through the written fashion, but also include our client's declaration or sworn statement with the response, then we get into the charges and the specifications. We list what the charges are, we list what the specifications are, and then we get into basically what the agency's burden is. Again, under 75, by preponderant evidence, under 714, by preponderant evidence, by Chapter 43, by substantial evidence. So we kind of list those legal standards and the agency's responsibilities. And then we get into the argument, conduct unbecoming, on this and this day, you were mean to your supervisor. We establish what the case law says about a charge like that, why that charge cannot be sustained in a case like this. And we do that for each charge and each specification. We also, for 75 actions, we get into why the charge conduct does not impact the efficiency of service. And then following there, we get into, for 75 actions and 714 actions, we get into penalty analysis. Assuming that the charges can be sustained, that the penalty, whatever that penalty may be, is beyond the bounds of reasonableness. And then we get into the 12 different Douglas factors as to why the penalty that's being proposed is not reasonable, and make those arguments. And then at the very end, we may raise affirmative defenses that we believe that the proposed action, for example, is being brought because of discrimination or because of whistleblower reprisal, whatever it may be. But again, with this response, we include evidence, one of which is our client's sworn declaration, responding to the factual allegations in the proposal, but also building up their background. And other statements, I encourage my clients to get character statements from people in the community, sometimes other employees, and then any documentation that we have that completely rebuts what the agency is arguing. We include all of that as part of our response. That response goes to a deciding official. It's designated in the notice that you receive. And then, the oral reply can happen before this written reply. Sometimes it happens after the written reply. There's no right or wrong approach. It really depends on scheduling and coordination. But those are two different replies that are provided. And these are the Douglas factors. So again, the Douglas factors apply only to whether the penalty can be mitigated. It does not apply to Chapter 43 performance-based actions whatsoever. So it does apply to Chapter 75, and it does apply, at least at the agency level, to Chapter 714 with the VA. So these are the factors. Number one is the nature and seriousness of the offense, and usually you look at whether the conduct was done intentionally or maliciously. And we always argue that obviously it wasn't. Number two, the employee's job level and type of employment. For supervisors, unfortunately, supervisors tend to be reviewed at a higher burden sometimes. And so if you're not a supervisor, we always indicate that here, and that you don't have a lot of public interaction outside of your position. The employee's disciplinary history. If the employee does not have a disciplinary history, that is a pretty strong mitigating factor. If they do have a disciplinary history, we tend to argue that the charged conduct here is different than the conduct that was charged previously, or maybe the conduct that was charged previously occurred 15 years ago and it's not relevant anymore. So this is where that would go. Their past work record, we argue that they had really good performance evaluations, and just going through the different awards that they've received. The effect of the offense upon the employee's ability to perform at a satisfactory level and the supervisor's confidence, again, arguing that our client is still able to perform exceptionally well. And this is important, especially when the employee is brought up on a proposal and they continue to work throughout, right? So there's a lot of employees that may get a proposed removal, but they're not taken out of their job while this notice period is happening. So they're continuing to work and waiting to receive a decision. So if that's the case, we like to put in here that, well, the employees continue to work, they haven't been taken out of their position, they haven't been detailed out of their position, so there should be no negative impact on the supervisor's confidence. Then we look at the consistency of the penalty, and we try to look at it compared to other employees that were brought up on the same or similar offenses. This is important information that we will receive as part of the response to the interim reply, something that I mentioned in prior slides that we do here. To get information like this, if someone is brought up on conduct unbecoming, well, I want to see other employees that were brought up on conduct unbecoming. If my client was brought up for removal and someone else was suspended, well, I think that's important, and we would make that argument with regard to the consistency of the penalty. We also look at it with the agency's table of offenses. If the agency's table of offenses say that the charged conduct here ranges between a letter of reprimand and suspension, but my client is being brought up for removal, again, there's a mitigating factor that would be argued. Kind of the notoriety of the offense or the impact on the reputation of the agency. This is pretty important because the agency, in my experience, abuses this factor and says that the employee's conduct can impact the reputation of the agency, and therefore they tend to argue that this is an aggravating factor. That's not going to fly, and that's not going to work. The MSPB has come down and says they need to actually show an impact on the reputation of the agency. For example, someone who did something and is arrested and it's reported on Fed Week or FedSmith, that, yes, you can say that's impacting the reputation of the agency. But in other circumstances where, someone was mean to somebody else and they're being brought up on the charge, it's hard to argue that's going to be impacting the reputation of the agency. The clarity of the defense, meaning that the employee was on notice of the rules. So, a lot of federal employees, if not all federal employees, go through training. So typically this is an easy thing for the agency to show that they were placed on notice, especially if there's prior misconduct of that employee. Even if it wasn't a reprimand, but like a letter of counseling, something that's not considered disciplinary, something that would not go in your performance file, but still, would essentially place the employee on notice that a violation of the agency's rule can lead to, an action. The other big one is the employee's potential for rehabilitation. And in my experience, this is the biggest factor that deciding officials and agency officials look at. They want to know that the employee can be rehabilitated, that they understand the severity and the action that's being taken against them, the government resources that went into it, that there's contrition from the employee with regard to the conduct. But more than anything, from my experience, deciding officials want to know that the employee learned from the issue, will change their conduct. And what I like to argue here, and what I encourage my clients to argue, is to show how they can be rehabilitated or how they have been rehabilitated and what they would do differently in the future should they be given the opportunity. 11 is other mitigating circumstances. For example, if there's discrimination or harassment happening in the workplace, we tend to include that here. And then finally, the adequacy and the effectiveness of other sanctions to deter the conduct. So essentially saying that removal is too harsh, a reprimand or suspension can be adequate under these circumstances. And we talked about the oral reply. The oral reply is a very important right here. It's your opportunity to really humanize yourself to the agency deciding official, as opposed to just doing it in writing. This is an opportunity to put a face to what's happening here, understanding your career is at risk, that your federal service is at risk. I think it's a very important opportunity to present your case in a different way than you would in writing, and to humanize the situation and to show the deciding official this impacts a real person, potentially a real family, and a real situation. The agency's decision typically has to be made within 30 days after the expiration of the notice period, and not occur before the 30-day period, no matter what. That said, these decisions do not always happen on the 30th day or the 31st day. They can happen anytime after that 30-day period. Yes, while the statute does say 30 days, in my experience, it doesn't often happen. I've had adverse action cases with notice periods that, unusual ones, but some that took several months, even longer, depending on what the circumstances may be. But typically, no less than 30 days. And then for performance improvement plans, this is more typical for Chapter 43 cases. A PIP is essentially a tool for the employer to give the employee with documented performance deficiencies and giving them the opportunity to perform and succeed. It may be used to address failures to meet specific job goals or critical elements that may be an issue. But a PIP only is issued if there's an issue with performance. And PIPs are typically issued when the agencies are ready to implement the Chapter 43 action. The reason why, and there might be some questions internally, as to why an agency might do a 75 performance-based action as opposed to a 43 performance-based action is for this reason. PIPs are very document intensive. They can go on for many weeks and sometimes many months. The agency and the person who's implementing the PIP needs to essentially meet with the employee on a weekly basis and document that through memoranda. There's a lot of paperwork that goes into it. And so sometimes it's easier for agencies to just go with the 75 action because they don't have to go through this process. But if they do go through this process, it is better for agencies to do a 43 action because they get the lower burden of proof. There's no mitigation of the penalty. But if you are given a PIP and you successfully complete it, great. There's not going to be an action taken against you, at least not for performance-based reasons. So you pass your PIP and you go back and do the same thing that you've been doing that got you to pass the PIP. But if you did not pass the PIP, it's very likely the agency will then propose the Chapter 43 action that can be a removal or a demotion. But again, it's only based on the performance reasons that the agency made the employee aware of, and only for that 1 year period. Just briefly, there's been a big change in Chapter 43 cases through Santos v. NASA that was issued by the Federal Circuit. Any cases that have been pending decision has to rely on the Santos case now. And essentially what it means is that before putting someone on a PIP, the agency has to show justification for putting that person on a PIP. So they basically have to show that the employee's performance was unacceptable before the PIP was implemented. If they did not do that, the case will be reversed. And so there's quite a lot of appeals pending at the Merit Systems Protection Board on that second level petition for review stage that are being reversed and remanded because of Santos. So any new PIP case, any new 43 case has to be compliant with Santos. And to the extent it is not, the agency's Chapter 43 action will be reversed and the employee will be reinstated back to their position. So we talked about the Merit Systems Protection Board, and the MSPB is an independent quasi-judicial federal administrative agency that was established under the Civil Service Reform Act of 1978. It has both original and appellate jurisdiction, and that's defined by regulation at 5 CFR Part 1201. Some of the cases we talked about, performance cases, misconduct cases, go to the MSPB. Suspensions up to a certain duration go to the MSPB. The MSPB also has jurisdiction over USERRA cases for federal employees, disability retirement cases after OPM issues a negative decision. So they have jurisdiction over a lot of federal employee matters, which is very important. But not every employee has a right to go to the MSPB. We talked about Chapter 74 employees, but it also excludes political appointees, various intelligence agency employees like FBI, for example, CIA, GAO employees, and probationary employees. Now, the probationary employees, again, I mentioned, there might be problems that the agency did and incorrectly stating that an employee was probationary when they're not. And then there's certain exceptions like partisan political reasons for the removal, for example, that will give a probationary employee the right to appeal. But generally speaking, probationary employees cannot go to the MSPB. And so the benefits of having an attorney. Hopefully I provided you with a lot of benefits. Here especially, we do this work pretty exclusively. But an experienced attorney will know what the issues are, have dealt with these agencies before, have dealt with these individuals before. They can identify the issues, they can identify the legal arguments, they will know the best way to present your case, whether it's at the due process stage on notice and opportunity or at the appeal stage. whether it's at the VA Disciplinary Appeals Board or the MSPB generally. There might be some mixed case components with regard to disciplinary actions. I mentioned the affirmative defenses like discrimination or retaliation. So an attorney can help with that analysis and that procedure. They can also negotiate with the agency at every stage, even at the due process stage at notice and opportunity. We typically deal with a lot of these agencies throughout not just this country, but outside the United States. And so we often know who to contact, how to speak with them, and see if there could be a resolution before a decision is issued. One of the other big benefits is the timelines. As you see here, there's a lot of different deadlines here, depending on what agency you work for and depending on which law that's being implicated for the action. So we are very much aware of these deadlines and the processes involved in that. But really, we are there to help you to present your case in the most effective way possible, whether it's at the appeal level, disciplinary notice level, or otherwise. So having a really good attorney who knows this stuff can go a long way. And that is our information. So if there are any questions, I know we only have a few minutes here. I am happy to review and answer them.
Alan, I'm going to send you over some questions that were submitted in your message on WebEx.
Great. Is the agency required to tell you which chapter they are using? Yes, they are. The notice requires the regulation and the statute that they are using to implement the proposed action against you. It makes a big difference, and their failure to do so would be a violation of due process, and therefore you would have a very good appeal if the agency did not include which chapter they're using. What are the deterrent actions for intelligence agency employees? So it depends on the agency. For example, FBI the Bureau has their own process with regard to disciplinary cases, and it's an internal process. There is one difference that I just became aware of recently for whistleblower cases for FBI employees. Apparently, they now have the right to go to the Merit Systems Protection Board, which is a big deal. But for disciplinary cases, intelligence agency employees don't typically have board rights. Again, there's exceptions that I'm not going to get into right now, depending on the intelligence agency and depending on whether or not you're preference eligible. So it does make a difference. But otherwise, there's always other options. While you might not be able to get to the Merit Systems Protection Board if you're an intelligence agency employee, every agency will have their own process internally. The only problem is you can't really sometimes take it outside of that process. What if an employee was not given any Calkines, Garrity, or Weingarten warnings? If they're not given those warnings, that's a violation of due process. So if they are entitled to those warnings and the action is issued, proposed, let's say removal, and then subsequently decided, and you appeal to the MSPB, you would raise a due process violation, specifically of harmful error for not being provided your Calkines warnings or Garrity warnings. That might be enough of an error for the MSPB to reverse the action on due process grounds. Sometimes, depending on how bad the violation was, the judges may, strike the testimony that you provided, but oftentimes, in my experience, the failure to provide these warnings at the appeal level will lead to a reversal on due process. Is Chapter 74 and 43 available outside of the MSPB? I'm not really sure what this question means. Chapter 43, if there is a Chapter 43 action taken, let's say performance-based action, and subsequently a decision is issued under 43, the employee's exclusive appeal would be to the Merit Systems Protection Board. For Chapter 74, again, if we're talking about major adverse actions for issues of professional conduct or competence, their exclusive appeal is the Disciplinary Appeals Board. And so I don't believe under those statutes, the employee can go anywhere else. However, they may have EEO issues, and the EEO issues may be raised at the EEO process. They may have whistleblower issues, and those issues, depending on the agency, would go to the Office of Special Counsel. But for the most part, federal employees have a very unique system, and it's a closed-off system, whether it's the MSPB for these types of cases, based on our webinar, or the EEOC, or the Office of Special Counsel, or the Disciplinary Appeals Board. And I believe that's all the questions. So I thank everyone for joining this webinar, and I hope you learned a lot today. I know it's a lot of information to get through in just 1 hour.